Dear students, welcome to the new class from the book Business Law. Here today I am going to share with you the second topic from that specific book. The topic name is Kinds of Contract. It's a very important topic for the students of BCom, newly named ADP Part 2. So guys, kinds of contract we can divide for our convenience or ease of understanding according to enforceability, according to formation, and according to performance. So one by one detail of each classification or kind for more proper understanding. Here comes. According to enforceability, contracts having further 6 subdivisions or kinds. First one is valid contract. Next to valid there is a void contract. After that void agreement, voidable contract, unenforceable contract, illegal agreement. So these are from 1 to 6 are subparts of according to enforceability. Next to that, according to formation. Here we have 3 further subcontracts named as express contract, implied contract, and quasi contract, also known as constructive contract. The third kind or classification of contracts, which is on your screen, that is according to performance. We have further 2 more kinds in that particular classification. The first one is executed and second one is executory contracts. Now you can see executory contracts, which are the part of according to the performance contracts, are of 2 further types. The first one is unilateral and second one is bilateral. Now we put emphasis first of all on according to enforceability. As I just mentioned earlier on, it has 6 further sub kinds. So let me explain you first, dear students, valid contract. As it is clear from the name, an agreement enforceable by law, and that agreement which fulfills the essentials of Contract Act 1872 of section 10, that agreement is valid contract. So if someone is going to constitute a valid contract, that person should consider all the essentials which are given in the section 10. Then after fulfilling those essentials, that contract would be a valid contract. Let me explain more. A valid contract is that which is enforceable by law and also creates rights and obligations on both of the parties. For more easy understanding, an agreement which fulfills the requirement of section 10 of Contract Act 1872, that contract is called valid contract. So a question arises in the minds of students. So what are those essentials? Those essentials, inshallah, will be covered in the coming lectures. But rightly, you have to keep your focus on an agreement which is enforceable by law, put rights and obligations on the parties, is a valid contract. Moving ahead, obligation of parties. When parties are in a valid contract or when parties enter into a valid contract. First of all, both parties to the contract are bound to perform their parts of promises. Secondly, if any party fails, the other can enforce through court of law. So these are the obligations on the parties as far as valid contract is concerned. So students, second one is void contracts according to section 2 subsection J. So let me explain you the word void and its easy interpretation. So void, you can say the word void means not binding in law, means such contracts does not put rights and obligations on the parties. So another interpretation, a contract which cannot be enforced by either party. Another way to explain void contract is a contract which ceases to be enforceable by law becomes void. So here ceases is very important to understand. It means there are certain contracts which were valid at the time of formation but becomes void or not binding for the party because of certain situations, because of certain circumstances. So here comes those situations or circumstances which makes valid contracts void. Number one, impossibility of a performance. So it falls under the circumstance. At the time of formation or at the time of making a contract, it was very possible or easy for the parties to perform. But at the time of performance, it becomes difficult, or you can say it becomes impossible to perform respective parts of promises. So contract becomes void because of impossibility of performance. Next, subsequent illegality. According to section 56, a legal contract may after formation but before performance. So keep your concentration on two words, formation and performance. Become illegal and as a result void due to certain reason. So this is a second reason, or you can say a circumstance, which is going to make a valid contract void, and that is named subsequent illegality. Now you can understand it was legal at the time of formation, now it has become illegal at the time of performance. So because of illegality, this valid has now changed into void. The third one is rejection of voidable contract. A party whose consent is not free, when rejects the contract, it becomes void. Voidable contract actually is that contract in which consent of either party is not free. Now, when a party whose consent is not free, having option to reject that contract. So after the rejection of that contract, it becomes void. Now till rejection it will remain voidable. So dear students, the fourth point is when depending event becomes impossible. So here comes the short description. A contingent contract to do or not to do something on the happening of an event becomes void when event becomes impossible. So here the happening of an event or not happening of an event is contingent to a contract. So when this depending event becomes impossible, will make your valid contract void. So in this particular kind of contract, obligation of the party are very important. Parties are not legally responsible to fulfill the contract, when the depending event becomes impossible. So parties would be released from their obligations on the basis of event which is no more possible for the party to perform. The next one is void agreement. So dear students, you have to be very much clear the difference between void contract and void agreement. Void contracts were valid at the time of formation, becomes void due to certain circumstances and reasons, or you can say on happening of certain situations or circumstances. But here void agreements are those agreements which are not enforceable by law. Void means does not create legal relations, or you can say these are those agreements which are void right from beginning. So that's why called void ab initio, means right from the beginning. So these agreements will not change into a contract, will not bind the parties, will not create a legal relationship between the parties. So students, remember, in void agreement, absence of one or more essential of a valid contract is present, or you can say one of the essential of a valid contract is missing, except free consent. So you can say free consent is present, but other essentials are missing. Here I would like to share with you the example like agreement with minor, agreement without consideration. Next, voidable contract, an agreement enforceable by law at the option of one party but not at the option of other. So it is a very unique type of contract. In this particular contract, when consent of any party is obtained by coercion, undue influence, or misrepresentation and fraud, then that contract becomes voidable contract. Second, promise to do something but prevents him from performing. So dear students, the third one is promise to do certain thing within a specified time but fails to do so, where the time is essence. Here in this particular kind of contract, which is voidable contract, obligation of parties are as under. It is valid and binding on both parties if it continues. The law gives one party to avoid the contract. The party entitled to cancel is not bound to cancel it. The aggrieved party can get damages from the other party. If party received any benefit, must return it to other. Next, burden of proof lies on plaintiff, that is simple and clear. The burden of proof will lie on a party who is suffering from the performance or feels that it is difficult for him to perform his part of performance. Next, unenforceable contract. Unenforceable contract is that which cannot be enforced in a court of law due to technical defects like absence of writing, registration, and missing of requisite stamp. It will become valid when all these technicalities are fulfilled. Here in this particular contract, obligation of parties are as under. Parties may perform the contract. In breach, the aggrieved party is not entitled to remedy. Illegal agreement, according to the section 23. Here the word illegal means against the law. When performance is forbidden by law, such agreement can never become contract. If permitted, would defeat the provision of any law. I would like to share a few examples. Fraudulent involves injury to person, property, agreements based on immorality or opposed to public policy. So here are punishment in law for the parties when they are going to constitute illegal agreements. Students, in the coming lectures, I will provide you insight about the remaining two kinds. So see you next time. Goodbye.